Thank you for joining iMeet. This meeting is now being recorded.
Hi, everyone. Thank you for joining us for the quarterly Veterans Fellow Legal Call and for the Discharge Upgrade webinar. I want to introduce you all to our guest speaker today, Antoinette Balta. Antoinette has her JD from Chapman University along with her LLM from Chapman University, and she is the president and co-founder of the Veterans Legal Institute in California, and she also is a VLC Fellow alumni and is the current project director for the Employment Opportunity Legal Fellow housed at the Veterans Legal Institute. And I will now pass it over to Antoinette to talk to you about discharge upgrades.
Awesome. Well, welcome everybody. Can you all hear me good? Maybe Renee can let me know. Am I coming in clear?
Yes, you sound great.
Perfect. All right. I wanted to say hello to all of you. Thank you all for your services, AmeriCorps. As Renee mentioned, I myself spent 2 years in service. I loved it. It was a wonderful opportunity. And one of the greatest parts of that experience was working with my fellow AmeriCorps colleagues like you guys that are really passionate for service. And every single one of them continued in his or her service and is really doing great things around the nation. So it's an honor to be able to speak to you today specifically about something that I feel very strongly about, which is discharge upgrade and really truly giving veterans a second chance. So we're going to go ahead and I'm going to give you a short overview about what we're going to be talking about today. And on the next slide, you will see here, we're going to go over kind of the basics of what is discharge upgrade, where the authority for these upgrades come from, the different venues of, where and how we apply for the upgrade, the applications or the forms, the practical stuff of how to do it. And then lastly, I'm going to give you guys some tips on case development. So one thing is, there's several of you on the phone and everyone has kind of a different level of expertise. So pardon me if some of it is elementary, or some of it is complicated. You are all always free to email me after the presentation, or if there's an opportunity through this software where you can ask questions, I'd be happy to answer them at the end. So we're going to talk a little bit about what exactly is a discharge upgrade. And discharge upgrade is a common term for the process in which a veteran asks the armed service in which he or she served to change the discharge information listed on his or her DD-214. That process often focuses on changing the veteran's characterization of service, but veterans may also request changes in other discharge information, for example, like their Reenlistment Code or their reason for separation from the military. Discharge upgrade applications are made to the veteran's armed service, not to the VA. So when you separate from the military, essentially there are 5 types of discharges. The first one, which everyone hears about, is honorable discharge. Under that would be a general discharge. Under that would be a OTH, or what's called an other than honorable. Under that would be a bad conduct discharge, or BCD. And thereafter, the infamous dishonorable discharge, or if it's an officer, it's referred to as a dismissal. So veterans who receive a less than honorable discharge from the military are commonly referred to as veterans with bad paper. So sometimes you may meet with a vet and he or she may say, I have bad paper. And that's what they're referring to, is that they have a less than honorable. So you may wonder, why might a veteran receive bad paper? So anytime there's misconduct involved in a service member's military service, the service member may receive a less than honorable discharge. And that can happen for a variety of reasons, ranging from less serious to more serious infractions. It could be minor disciplinary infractions, stuff like being late to formation a few times or having an argument with a superior. It could be for a pattern of misconduct, and that's where there's a minimum of 2 incidents occurring within 1 enlistment at least. It could be minor, it could be more serious, and the incidents don't have to be of the same nature. It could be for a commission of a serious offense. That might include drug use. And lastly, it could be for a civilian conviction. Now, what are the documents that we're talking about? What are these, relevant documents to discharge upgrade? So as you all, I hope, know from now, that when a veteran leaves the service, they receive discharge documents, and the most common of which is called the DD-214. I often refer to it when I speak with civilians as like when you graduate high school, it's like your diploma. What some people may not know is that your DD-214 comes in two forms. It comes in a long form and a short form. And both the forms contain general information, and that includes, the dates of entry and discharge, your total time in service, your rank, decorations, and military education. But the long form includes more things, more information, like characterization of service, which is, whether they're honorable, other than honorable, general, under honorable, bad conduct, or dishonorable, etc. The reason for their discharge, which is typically, completion of term of service or medical disability, etc. It also includes their Reenlistment Code, indicating the circumstances under which the veteran can re-enter the service. And it also has a 3-letter or number code matching the reason for discharge. So on this DD-214 is a narrative reason for separation. And there are a lot of reasons people separate from the military, including those which potentially negative connotations. So I wanted to give you some examples so you knew what that looked like. It could be misconduct, hardship, disability, erroneous enlistment, alcohol abuse, rehabilitation failure, homosexual conduct, personality disorder, and other things. So you can understand that sometimes, even though someone has an honorable discharge, they may want to get the narrative reason for separation changed, and you would still have to go through the upgrade process to do so. So occasionally, the reason for discharge can act as a statutory bar to receiving VA benefits, and simply upgrading the status of your discharge may not be sufficient to become eligible for VA benefits. And so that occurs when typically your discharge was a result of a general court-martial, you were a conscientious objector refusing certain orders, you were discharged as a deserter, discharged as an alien who requested discharge in a time of hostilities, and there are a few other examples as well. So we're going to talk a little bit about reenlistment codes. The Reenlistment Code indicates eligibility for reenlistment into the military. Some people complete their enlistment and they want to reenlist. And the way you know, typically one of the ways you know whether or not they have the opportunity to reenlist is by looking at this code. So it will happen from time to time that a veteran will come to you and say, I want to change my reenlistment code. So there are 4 types of codes. It will say either RE1, RE2, RE3, or RE4. RE1 allows immediate reenlistment, so they're okay. A 2 or a 3 requires various levels of waiver for reenlistment. However, if you have an RE4, that bars reenlistment unless the code is changed, not just waived. Only the BCMR has authority to change that reenlistment code, and we'll talk in a little bit about the BCMR. But before we get into that, I love to talk about discharge upgrade myths. It drives me crazy, all these things that people say that aren't true, and it's been happening, forever. And I'm sure that many of you out there have heard these same myths. And the biggest one, and the one that just makes me mad, is that, oh, hey, it's okay if we get you, if you get a less than honorable 6 months after you separate, you automatically get upgraded if you apply. So that's not true. And this myth has been around since World War II, believe it or not, and it's still being perpetuated by people marginally involved in the discharge process, including personnel specialists and NCOs. So typically, veterans will come to you and they'll say, hey, but they told me, as long as I stay clean and I'm okay, then the discharge would go to honorable in 6 months. It will be a sad conversation that you will have to have that, I'm sorry, sir, I'm sorry, ma'am, but unfortunately, that is not the truth. Another myth that is being spread is that regardless of the reason for your discharge or what's in your disciplinary record, a discharge upgrade will obtain long as an excellent post-discharge post-discharge history can be documented. So it's like, oh, I got out of the military, I wasn't on my best behavior, but since then I've been good, and they said that I would get automatically upgraded. That's not true. Discharge upgrade process is actually quite difficult, and you really need to prove to the correct venue that the veteran is in fact entitled to that upgrade. And the last myth I wanted to discuss that, I have a less than honorable, so I'll never get VA benefits. I'll never get health care. That's not entirely true. There are other avenues to that, and we are going to discuss them. So back to the basics. Why apply for a discharge upgrade? And if we were in a room together, I'd ask everyone to kind of give a reason. But, you know, veterans may apply because they think their characterization of service is wrong, or to avoid the stigma often associated with unfavorable military discharges, to establish eligibility for VA benefits, or for increased employment opportunities. But what's really important is that as soon as you meet a veteran and they say, hey, I want a discharge upgrade, you have to ask why. You need to understand why they're seeking this upgrade. And everybody has a different reason. There are alternatives, believe it or not, to discharge upgrades. And a lot of people don't know this. A lot of veterans don't know this. A lot of people at the VA don't know this. But if your veteran's sole goal is to establish eligibility for VA benefits without upgrading their characterization of service, they may instead apply for something called a VA character of service determination. So the VA can grant basic benefit eligibility to any veteran discharged with a less than honorable discharge, except those who received a bad conduct discharge or dishonorable discharge as a result of a general court-martial. The VA cannot alter your discharge status, but instead they make what's called a characterization or character of service determination, that while your discharge may be less than honorable, your service overall for purposes specifically for VA healthcare was honorable. So moving on, I'd like to talk to you about the different types of discharges, and you'll hear it from your veterans. They'll say, I was administratively discharged, or I was punitively discharged. So the types of discharges are, you can be administratively or punitively discharged. And in terms of administrative discharges, those are less serious in nature. They cannot be given by court-martial, and they include your honorable discharge, your general under honorable, and your other than honorable discharge. However, if you are punitively discharged, that's more serious. It can only be given as a sentence from a court-martial, and the court-martials can issue punitive discharges, but they don't have the authority to grant the less serious administrative discharges. So if it's punitive, it means they either have a bad conduct discharge, a dishonorable discharge, or again, for officers, it's referred to as dismissal. Summary court-martials cannot issue any discharges. Special court-martials may only issue bad conduct discharges, and only a general court-martial can issue a dishonorable discharge. Now, there are exceptions to those two categories of administrative and punitive, and that includes a medical discharge, which isn't really classified as administrative or punitive, and it's handed through a completely separate process. So what gives us the authority to apply for these discharge upgrades? And I throw this slide in there because you're attorneys, and attorneys always love the authority. And so here it is listed on the slide. Congress established the Military Discharge Review Boards and the Board for Correction of Military Records shortly after World War II with the basic intent to correct any regulatory errors or inequities found in military personnel records. So moving on from here, we're going to talk about the venue for these discharge upgrades and the forms to seek relief. So you've all heard DRB, BCMR, and we always hear these different letters. Those are the main two, although there are, future sources if you've exhausted those two venues. First one is the Discharge Review Board, known as the DRB. We would use a form DD-293 for that. And with the Discharge Review Board, you have a choice of either a records review, or if there's time, or I guess we would say a personal hearing. With the Board of Correction of Military Records, the BCMR, that would be, we would file a form DD-149. And if we've exhausted those remedies, we could go on to federal court. So each of these venues has its own advantages and disadvantages of rules and presumptions and burdens of proof. So boards presume, remember this, that the records are correct as issued, and the applicants or the veteran must provide material evidence showing that their records should be corrected. So I'm going to get into the nitty-gritty of the Discharge Review Board, or the DRB. So I had spoken earlier and I said, we don't apply to the VA. We actually have to apply to the Military Branch Discharge Review Board, or BCMR. So each military branch has its own Discharge Review Board. You've got the Army, the Air Force, the Navy, the Coast Guard, and the Marine Corps actually apply under the Navy boards. There is a strict 15-year statute of limitation. The Discharge Review Boards have strengths, and they have basically authorities and limitations. So amongst their authorities is they can change the reason for your discharge, provided the change represents an enhancement of the applicant's rights. They can review bad conduct discharges issued as part of the sentence of a special court-martial, and they can upgrade general discharges to honorable, other than discharges to honorable or general, bad conduct discharges from special court-martials to honorable, general, or other than honorable, and they can change discharges in other various ways. But where are their limitations? What can the Discharge Review Board not do? Well, the jurisdiction is limited to review of the character of service and the narrative reason for discharge. You cannot see, well, the DRB cannot see veterans discharged or dismissed by general court-martial, and that includes all veterans with dishonorable discharges. Veterans discharged by special court-martial may only request a change of characterization of their discharge, and they will only be granted discharge upgrades for purposes of clemency. The DRB cannot overturn or pardon or eliminate the findings of a court-martial. They can't lessen your discharge. So once in a while, a veteran will say, well, if I apply, is there a chance they'll even give me a lower characterization? And no, they can't do that. So you either stay where you are or you get an improvement, which is a nice safety net for us. The DRB can't change your Reenlistment Code or otherwise modify the contents of the veteran's military record. They can't make decisions regarding disability and retirement. They can't reinstate veterans into military service. They can't recall any person into active duty. There's a few other things. So moving on to the Discharge Review Board standard of review. I've listed the code there where you could find it, but generally the Discharge Review Board only upgrades discharges on grounds of either equity or propriety. So we're going to talk a little bit about both of those. Propriety issues relate to the regulatory correctness of your discharge. A Discharge Review Board can upgrade a discharge on grounds of propriety for two separate reasons. The first is an error of fact, law, or procedure occurred, and the error was prejudicial to the veteran during the discharge process. Or the second reason would be a change in policy has been enacted, and the change is expressly made retroactive to the type of case. We saw that with the ADT, which don't ask, don't tell, right? So moving on, continue into, we spoke a little bit about propriety, now talking about equity. Equity issues concern any extenuating or mitigating factors that have contributed to the veteran's discharge. So Discharge Review Board may upgrade a discharge on grounds of equity for three reasons. First one is the current discharge policies and procedures are materially different than those that led to the applicant's discharge. So for example, a discharge may be deemed inequitable if there is substantial doubt that the applicant would have received the same discharge if relevant current policies and procedures had been available to the applicant at the time of the discharge proceedings under consideration. Second one is the discharge was inconsistent with disciplinary standards at the time of discharge. The third one is based on evidence relating to the quality of service or their capability to serve. So for determinations based on that quality of service, the DRB may consider, although it's not limited to this, but factors including the applicant's service history, military rank, ratings, awards, decorations, letters of commendation or reprimand, wounds received in action, acts of merit, length of service, prior military service, convictions by court-martial, non-judicial punishment, civil convictions, records of unauthorized absence, records relating to discharge, etc. In terms of the evidence relating to their capability to serve, the DRB may take into account overall total capability. So, age, education, ability to adjust to military service. Specifically in those terms, an example would be a lot of people had started serving at a very young age. They'd never been out of their house before. They're high school graduates, and they may struggle in assimilating into military culture. Another thing they may consider on capability to serve would be their family and the personal problems that may have affected their ability to serve. Arbitrary actions by individuals in authority over the applicant, and perhaps discrimination is documented by records or other evidence. So an example may be a service member developed post-traumatic stress or went AWOL after news of a family emergency. So if an applicant is discharged by special court-martial, the discharge may be upgraded only for purposes of clemency. And 5 years is generally viewed as the minimum amount of time required to establish sufficient post-service accomplishments to merit consideration of this issue, and sometimes even longer. So continuing to the standard of review, the Discharge Review Board may consider previously denied applications that meet certain standards of review. So a board may consider or reconsider an application when the previous consideration was on the motion of the DRB rather than the veteran, and that's very unusual, but it can happen. When the applicant did not have a personal appearance hearing for the first application, but the applicant now requests a hearing. When the relevant discharge policy has changed and has been made expressly retroactive. When current discharge policies and procedures are substantially more favorable to the applicant than the discharge policies and procedures under which the applicant was discharged. The veteran was not represented by counsel or representative in a previous application, but will be before the reconsideration, or perhaps when the applicant presents new substantial and relative evidence that was not available to the applicant at the time of the original review by the DRB. So I had just mentioned that, sometimes if you didn't have a personal hearing, you might get that second bite of the apple. And what I meant by that is sometimes if you're within, if you're timely, you can get 2 bites at the apple, where we can talk about records review versus a personal hearing if you want both, and this typically comes down to strategy. So the DRB applicant can choose to apply for a records review or a personal hearing. Things that you would take account when making that decision is the strength of the arguments and whether they can be presented well in a written application, the client's personality and ability to present the case, costs of travel, and timing. In terms of records review, they're limited to consideration of available, keyword there being available, medical and administrative records, as well as any material submitted by the veteran. The boards usually don't look at court-martial records of trial, just at the charges and results. The veteran can be represented by an attorney or a counselor. If you're denied at the record review letter and you're still within the statute of limitation, the veteran can apply for a personal hearing, and the applicant will receive decisional document explaining the reasons for the denial. In terms of the personal hearing, this time they're held in Washington, D.C. Sometimes they've had traveling boards, and it comes and goes typically depending on what's going on with that DRB at the time. At the personal hearing, you're allowed to be represented by a lawyer or a non-lawyer counsel. An opening by counsel is generally made, as is direct questions of the applicant by counsel, then followed by questions from board members and a closing statement by counsel. Witnesses can also testify at these hearings. When the veteran testifies under oath, the board members can question them, and some veterans prefer to make unsworn statements to avoid this. It's a tactical decision best made, between you and your client. It is a fact, there are statistics that if you attend a hearing versus just a records review, you are substantially more likely to receive the discharge upgrade. If there is a previous denial through records review, the board members will have a copy of that said denial. That being said, so will you. So you can actually, attack the arguments for denial at your personal hearing. So as I mentioned, time permitting, with the exception of the Coast Guard, you can have 2 shots at the apple. Moving on from the Discharge Review Board, we're going to talk about the second most popular venue, which is the Board for Correction of Military Records, commonly known as the BCMR. They do have more authority than the Discharge Review Boards. They can do almost anything to a veteran's records except overturn a court-martial conviction. Veterans applying after the 15-year time limit for the Discharge Review Board must proceed to their service department's BCMR. They must apply within 3 years of discovering the error and justice or date of most recent unsuccessful DRB decision. I bet you're thinking right now, oh my gosh, 3 years. Well, I'm seeing Vietnam and Korea era veterans. So much time has passed. And the response to that is that 3-year rule is waivable in the interest of justice. So you're going to you must actually argue this in your brief that the merits of the case warrant a waiver in the interest of justice. The BCMR cannot determine whether to waive the 3-year limit without making a cursory review of the merits of the petition. So again, I cannot say how much you must request the waiver in your application. Ignorance of the law is not a strong argument. So almost anything else, I think they're pretty easygoing when it comes to waiving that 3-year time slot. So we had already talked about the DRB and their authority and their limitations. We're going to do the same with the BCMR. The BCMR has authority to upgrade any discharge characterization and change any reason for discharge. They can upgrade discharges issued by general courts martials and can upgrade special court bad conduct discharges if a DRB refuses to do so. They can void discharges. They can change reenlistment codes. They can change the date of the issue of a discharge. People want to do that sometimes because it results in back pay. They can remove inaccurate performance evaluations or other damaging documents from the record. And in very rare circumstances, they can reinstate veterans back into military service. So the BCMRs can change the reason for your discharge to or from medical disability retirement or discharge. And in some cases, the BCMR will decide a veteran should have been medically retired as of the date of his or her discharge, resulting in a disability pension retroactive to that date. So that's really important. You will come across in your service veterans who say, you know, I got out with an honorable, but I really should have been medically discharged. So even if they're within that first 15 years, you still go to the BCMR for that, because only the BCMR can change a regular, I guess, discharge per se to a medical discharge. And I'll tell you a quick story about my experience as an AmeriCorps working on a case like that. I had a OEF-OIF veteran who served in Afghanistan, had some headaches, was complaining, was eventually sent to Tripler and 2 other major VA hospitals, and eventually was let out of the military, separated from the military with a regular type of discharge. He wanted to get a medical discharge, not for the money, but he wanted private insurance because the VA hospital was 60 miles from his house. And what turned out was he actually had a tumor the size of a golf ball in his head. And the VA somehow didn't discover that. As soon as 3 days after he got out, he went to a private doctor. They did a scan. They found this tumor. So it wasn't difficult to prove that, you know, this tumor developed during his period of service. We applied to the BCMR, and it took them about 5 months to respond, indicating that, yes, they were going to change him to a medical discharge. Unfortunately, we received that about a week after this veteran had passed away. So not a total happy story, but it was a vindication for the family somewhat. Okay, now what can the BCMR not do? They can't lower your discharge. So again, fear not if you think, oh, I don't know, maybe what if they take him from an other than honorable to a bad conduct? It's not the case. They cannot lower your discharge. At worst, they deny the upgrade and leave the veteran where he or she is. The BCMR cannot compel the attendance of witnesses. So it's not like you can subpoena people like you can in criminal courts and force them in. They won't do that. They cannot expunge a special or general court-martial conviction. Though the correction boards cannot overturn a court-martial conviction as a matter of law, they can and sometimes will order that the records be corrected to show that the convening authority approved only part of a sentence. So also, they cannot award payment to veteran for expenses incurred in preparing an application and presenting a case to the board. So as of today, there are no attorney's fees that you can win if you get the upgrade, unfortunately. And lastly, if a veteran is eligible to apply to the Discharge Review Board, but thinks, you know what, I'm going to go to the BCMR instead just because I think my chance is better, the BCMR is going to kick that back and they're going to require the veteran to apply to the DRB first. So unlike DRBs, there is no clear code of standard of review. The BCMR may change military records of any member or former member of the armed forces to correct an error or injustice, and those 2 words are key. Discharges issued by special or general court-martial may only be upgraded on clemency grounds. And, you know, the BCMR's things that they consider in terms of that, our post-service conduct is very important when deciding whether to grant a discharge upgrade, especially when an applicant seeks to upgrade their discharge issued by a court-martial on clemency grounds. They'll consider surrounding offenses. They'll consider evidence of subsequent rehabilitation. They'll consider good post-service conduct. They'll consider evidence of exemplary citizenship and character. So that's kind of what we know about their standard of review. This slide is intentionally short. With the DRB, sometimes I said you get 2 bites of that apple, you know, records review and a personal hearing. Well, the BCMR rarely grants personal hearings. If you get denied by the BCMR, you may request reconsideration. Even when the only option a person has left is Board of Corrections, a person can generally make repeated attempts at this level as long as there's new and material evidence to submit with the new request. The Army limits the number of attempts at the Board of Corrections, however. And even for the other boards, there may be reason to wait to file a request. For example, perhaps you want to demonstrate a better post-service history. So the request for reconsideration must contain that new material evidence. An applicant must show the evidence was not reasonably available at the time of the previous application. Veterans can also appeal BCMR decisions in federal court under the Administrative Procedure Act. And the APA has a 6-year statute of limitation from the board decision. And this is the part of the MCLE that I love the most. A lot of times I'll attend trainings and they'll kind of give you various ideas or general theory, but they don't really tell you how to do something. You know, this is it right here. This slide is so important. The Discharge Review Board, you need the form DD-293. The BCMR, you need the form DD-149. These forms are relatively easy to fill out. They're self-explanatory. They're not intimidating, and they're, 2 or 3 pages. That's it. If you want to request military personnel files and medical records, one way to do that is through an SF-180. There are other ways as well. The reviews take several months, and supporting documents can be submitted for weeks after the application has been filed, as long as the board has not yet reviewed the application. However, I will say that I always prefer, if possible, to send everything all at once. Things get lost all the time. There are tens of thousands of these applications being made a year. So if you can, if you're not under a huge time constraint, send everything at once, a full package. It is usually better. We're going to move on now to how do we prepare this application? I told you if it's DRB, you need a DD-293. If it's BCMR, you need a DD-149. But what else is it just that form? And the answer is no. This is what separates attorneys from, VSOs or, most VSOs or other people that have good intentions to help but may not have the time or the research skills that attorney has. A lot of people will just fill out that forms and send it in, and then we wonder why so many of these discharge upgrades are unsuccessful. But you, as a zealous advocate and attorney, you're not going to do that. You're going to go all out for your veteran. You're going to prepare a brief and statement of material contentions, and that will also double as your table of contents. You're going to research regulations to see if there are new regulations that would have been more favorable to the veteran. You're going to research court cases and old board decisions for similar cases. You're going to research and develop equitable arguments, propriety arguments. You're going to check for common procedural errors, and you're going to research and develop clemency arguments. And while you're doing that, you are going to start collecting evidence. And as soon as I meet with my veteran, I kind of give them a questionnaire to fill out to see if this is the type of case I'm going to take. But I also let them know, hey, while I'm reviewing your case or while we're waiting for your military records, I'm going to need some other stuff. Maybe you could get me witness statements. Maybe, you can get me letters from healthcare providers or school or employment records or proof of community standing, proof of a clear criminal record. We could do a FOA request for your court-martial transcripts. And I always request that the veteran write a declaration. So we have the DD-149 and the 293, and then we're going to submit additional materials, kind of like the ones that I just mentioned, and also a brief which summarizes the favorable aspects of applicants' military performance, highlights factors that may mitigate disciplinary records, and explains why the upgrade should be awarded. I always submit as many copies as there are board members. Now, I've asked in the past, we've actually called in and said, hey, do we need to just send, they'll say just send one copy, but I have also read in other places that you should send one copy per board member. There's, sometimes 5, depends on the venue. Apart from the brief, you're going to submit a statement of material contentions, which will double as your table of contents and which lays out the issues that you want the board to address. A sworn or notarized veteran statement or declaration that explains the reason for the upgrade, evidence and request for clemency, evidence of in-service conduct, which could include witness statements, good performance reviews, or any evidence of misinformation from command officials that cause the service member to waive important rights in disciplinary or discharge proceedings. Evidence of post-service conduct that is positive. That could include character references, employment documents, education documents, police clearance showing absence of criminal record where applicable, rehabilitation documents where applicable, etc. The DRBs and the BCMR start with a legal presumption that discharges are fair and legal and that military officials act properly. They pretty much say, you know what, the military knows what they're doing, and if you got separated with a less than honorable, it's most likely because you deserved it. So therefore, the veteran has the burden of proving that his or her discharge should be changed. Proceedings are considered technically non-adversarial, so there's no attorney representing the military side, but board members may be critical and sometimes suspicious at hearings. The rules of evidence don't apply, though vets and their representatives can object to offensive questions or unnecessary invasions of their privacy and questions that simply aren't relevant to the case. You know, rest assured the DRBs and the BCMRs do not normally make any independent investigations, but there are a few, you know, exceptions. Sometimes the board will check to see if an applicant with a bad conduct discharge has a later civilian conviction. The BCMR may ask for advisory opinions from OJAG, the service's medical or personnel experts, and on very rare occasions from the Vets Old Command. Or more investigation may be proper in Military Whistleblower Protection Act cases. So with punitive discharges, remember we said that those were the bad conduct discharges and dishonorable discharges or dismissal for officers. The board will upgrade only on the basis of clemency. This means showing rehabilitation and excellent conduct after the offense and especially after discharge. In addition, it can help to show extenuating or mitigating circumstances relating to the offense. It's virtually always helpful to begin gathering documentation and evidence for discharge upgrades during the discharge process and right after discharge, even if the veteran doesn't plan to request an upgrade soon. So since evidence, records, and witnesses can get lost, this task should not be put off. And it could include getting a complete copy of your military personnel record, outpatient medical records, any inpatient hospital records, the complete copy of the discharge packet sent to the separation authority, complete copy of all the files kept by their civilian or military attorneys, any sort of records or documentation, any sort of letters from fellow services who are aware of the veteran's good character or mitigating circumstances surrounding misconduct, innocence of alleged misconduct, command bias, etc. So if you have gone to the DRB and the BCMR and you haven't been successful, you do have other options. You can appeal to federal court. The monetary claims in federal court must be limited to $10,000. There's a 6-year statute of limitation, which runs from the date of the denial from the reviewing board. Or in the alternative, you can appeal to the Court of Federal Claims. You know, there's you need over $10,000 to use the Tucker Act in the Court of Federal Claims, and that has the power to reinstate the veteran into military service or award back pay, correct military records, to remove any references to the illegal separation award accrual of active duty days. You're not required to exhaust all administrative remedies to go to the to appeal to the Court of Federal Claims, but there is generally a 6-year statute of limitations that runs from the date of discharge, and the court may use the doctrine of lashes if it finds unreasonable delay in the veteran's claim. And you can see on this slide that I kind of made a very quick chart for you all to see. And moving on from here, one of the greatest questions I get from people is, what's my chances? What are my chances, you know, if I apply? And years ago, my colleagues and I, we conducted a FOA request to the different military branch DRBs and BCMRs, and we did receive responses from some of them. And what we received at that time was typically it hovered around 10%, give or take, for each of the service branches. But when you had an attorney involved, there was a huge increase in the rate of success. If you had a personal hearing with an attorney, you know, your chance of success skyrocketed. And what this tells us as public interest attorneys, as Equal Justice Works AmeriCorps legal fellows, is when you come into the mix and you start assisting a veteran and you take this time to do your research and collect evidence and draft a brief and put this all together and perhaps even attend a hearing in DC, or the chance of that veteran receiving the upgrade is substantially higher. And if the veteran receives that upgrade, the change in their life is huge. For example, they may be able to access benefits where in the past they couldn't. They may be able to get that job in the government where in the past they couldn't. You may have reinstated their own self-worth because while they may not have needed the discharge per se for monetary or health reasons or employment reasons, they may have just felt really bad about having a less than honorable when they felt they in fact did deserve an honorable. So, you know, when you are successful and you're doing this work, you really are doing life-changing work. Even if you don't win, at least the veteran knew that there was someone there who cared enough to advocate on his or her behalf. So it's great work that you all are doing. And that concludes this presentation. I want to thank you all for listening, especially because this is a 3-hour presentation that I give that I attempted to condense into 45 minutes in case there were any questions. I'm not sure if I'm able to, if there's the ability for people to ask questions on this software platform. But if you do have any questions and we can't do it that way, my email is on the screen. It is the best way to reach me. And I am happy to support any of my fellow colleague AmeriCorps in discharge upgrade, veteran benefits, or any other area of the law. So thank you very much and have a wonderful day.
Thank you, Antoinette. And we do have some time and a platform for questions. Fellas, if you do have questions for Antoinette, you can type them into the chat bar now. I'm also going to open up the phone lines if you're joining us that way. And I'm going to ask that if you're not asking a question and you're on the phone, please mute your phone on your end so we don't hear the background noise. And when you ask the question, please introduce yourself and your host site. So go ahead and ask your questions now.
All guests have been muted. All guests have been unmuted.
Guys, if there aren't any questions, I want to kind of share another story with you. And it's becoming a more and more common issue that we're seeing amongst veterans. We're seeing veterans, some have honorable and some have less than honorable characterizations. But what happens is in their narrative reason for separation, which is on the long form DD-214, where it says their reason for separation, it will say homosexuality. Now, when you're applying for a job, especially if it's a government job and they request the long form, even if you have an honorable, some people are less than comfortable with their sexuality listed on their long form DD-214, or they don't think that it's there's any purpose of that being there. So with the repeal of Don't Ask, Don't Tell, you can apply to the BCMR, and those are always awarded. If you do the paperwork the correct way, you are going to get that removed from that person's DD-214. And when you do that, again, apart from perhaps removing any stigma they may feel, you are potentially helping them remove a barrier to employment because of discrimination that does exist against them. So we've done that for several veterans. It's great. People don't realize how actually easy it is, but it is easy. And if any of you encounter that issue, please feel free to reach out to me, and I'm more than willing to share a sample with you so that you can use it kind of as a template.
Excellent. That's great information to have. And we have one question here I'll read out from Brittany Horton, who is with the Legal Services of Greater Miami. She asks, how do you know if this is a case that you should take?
Okay, that's a great question. I would say for every for every 10 discharge upgrade applications I receive, I take one. I typically only assist if there is proof of a mental health issue that arose due to the service or that existed during service. If there was a traumatic event that caused the mental health illness, something like military sexual trauma, rape, watching a colleague die, being the one to, like combat medics often have post-traumatic stress disorder. That needs to exist usually for us to take on the case. There are exceptions. For example, we received a discharge upgrade from a African-American gentleman who separated from the military in the 1940s. there was no trial, but he was accused of rape by a woman who he did not know. There was no trial. There was no police investigation. It was just a way to push him out of the military. There's documented evidence during the 40s of huge race issues, and so that is one that we would take on as well. But basically, I have a questionnaire that I developed. It's pretty easy. It asks like 6 or 7 questions to give me an idea. And it's kind of like, you know, why were you separated with a less than honorable? Was there a specific event? Stuff like that. And what I do is I review that questionnaire, and then I review, or I order and then review that person's military documents and sometimes medical documents to verify the story. And if I feel that there's a strong, a strong reason that this person should have been initially separated with an honorable discharge, then I will take on the case.
Great. And we've got another question from Brittany Horton. Will a board upgrade an AWOL when the veteran has a general discharge already?
So there are specific rules when it comes to when you're when you go AWOL. And so so the person has a general under honorable, is that what you said?
Yes.
Okay, sorry. There's a lot of noise on my end, and it's hard to hear. So there are specific rules in terms of, like, if you have sort of unauthorized absences, it depends on the period of the absence. If it was for example, 180 continuous days or more, and there are some exceptions. You're just not going to, it's a statutory bar. So I guess what I would suggest is looking into the statute and reading up on the statutes to see if they even qualify for the upgrade. Going UA or AWOL is a big no-no in the military, so it can be very difficult to get the discharge upgrade on that.
Thank you. And we don't have any other questions right now, but we will hold to see if anyone has any on the phone line. And if you're not asking a question, please mute your phone because we can hear some background noise. Okay, it doesn't look like we have any other questions right now, but as Antoinette said, her email address is shared here on the slides, and I will share it in the follow-up email along with a copy of the slides and the recording from this webinar, so you can follow up with her then. And I want to thank Antoinette for joining us today, for giving us this great presentation, and thank you all for joining. Have a great afternoon.
My pleasure. Thank you. Take care.